Welcome back to Law Stash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss a case dealing with community caretaking exception to the warrant requirement under the Fourth Amendment. We're also going to look at a distinction between homes and automobiles. For example, what's reasonable for the officer when he's conducting a search of an automobile may be different from what's reasonable when he's conducting a search of a home. And before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button and the notification bell button, so next time I post, you're first to know. And if you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support my channel, consider going to lawstash.com and looking at some of my merch, including these Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing a federal case, United States versus Hewitt. So let me first run through the facts. Police received 3 anonymous calls over a short period of time about room 322 at Extended Stay Hotel. The first call came in at 11:30 in the evening, and the caller said that she was hearing a lot of yelling from the room and a smell of marijuana. 2 officers were dispatched. They didn't smell anything, they didn't see anything, so they left. Around 1 a.m. in the morning, the same caller rings up 911 again and says that she's hearing more banging on the wall and more yelling. The officers were then dispatched again, the same 2 officers. They see nothing, they hear nothing, and they don't smell marijuana or anything related to drug sales. So they leave again. At 1:45 in the morning, officers received the call from the same caller the 3rd time, and she says that when she was in the hallway, she saw a short black individual wearing blue jeans, white t-shirt, and a black jacket, and he told her to mind her own business. So instead, she calls 911, makes this description to the officers, and she also says that the previous day, the same individual flashed a handgun at her. So the same 2 officers were dispatched. They came over. They walked around the hallways. They didn't hear anything again. They didn't see anything. And by their own admission, they didn't have probable cause to search the room because they didn't see any crime being committed. Nevertheless, they came up to the door, which was slightly open. There was a slight crack between the frame and the door. The officers testified that they couldn't see anything inside. It was too dark. So the officer, one of them, decides to kick/push the door to open it. It opened halfway. It was still dark. The officers announced themselves, and then they pushed the door completely open and walked in. They found marijuana and a handgun. With that information in hand, the officers went to the judge and got a warrant to do a complete search of the room. After the search, they found marijuana, more edibles, more cash, a cell phone, and a receipt with the defendant's name. Mr. Hewitt argues that this was a search illegal under the Fourth Amendment because the initial entry into the room was without a warrant and they didn't have any probable cause to get the warrant. And then he also argues that the subsequent warrant was obtained with information that was used and found illegally in the first search. And thus the warrant should be suppressed under the fruits of the poisonous tree, and the subsequent search is also illegal under the Fourth Amendment. Remember, the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Of course, you have a reasonable expectation of privacy in your hotel room. It is just like your home or automobile. you do have reasonable expectation of privacy there. And of course, without an exception to the warrant requirement, the subsequent search would be illegal under the Fourth Amendment. The government cites the so-called community caretaker exception as justification for the officers dispensing with a warrant requirement in entering the hotel room. Community caretaking functions include established procedures or routine activities, such as impoundment of a vehicle that impedes the safe flow of traffic, entry into a car after a traffic accident to assess occupants' medical conditions, or opening a trunk compartment to identify the owner. The community caretaking doctrine also extends to activities protecting the safety of persons or property. Courts have distinguished this doctrine from a separate but related exception justified by exigent or emergency circumstances. The community caretaking doctrine requires a court to look at the function performed by the police officer, while the emergency exception requires the analysis of the circumstances to determine whether the emergency requiring immediate action exists. Thus, as the district court noted, the doctrines have different intellectual underpinnings. The community caretaking exception has traditionally been used in connection to automobiles. In fact, some courts have called into question the validity of this exception when dealing with homes. That is because what's reasonable when conducting a search of an automobile might not be reasonable when conducting a search of a home, because your home gets the most protection under the Fourth Amendment and it is explicitly listed in the Fourth Amendment. Nevertheless, the court moves on and discusses the community caretaking exception in these circumstances. Here we have reports of loud noise, yelling, banging on the wall, but the investigation by the officers themselves revealed no people, no noise, no odor of marijuana. The investigation revealed no evidence to substantiate the reports by the anonymous caller. And when dealing with the handgun that the caller saw the day before, we're dealing with over a 10-hour span between the call to the 911 and the viewing of the gun. So we have some period of time, and there was no evidence that the person holding the gun was in distress or threatening anyone. And again, we're dealing with a 10-hour period. The government says that the officers needed to go into the room to see if anyone overdosed on drugs. Overdosing on narcotics is a big issue in the county, and officers need to make sure that individuals inside were safe. Now, the court says that this is a real concern. However, we don't gut the Fourth Amendment on mere speculation. Here, there was no evidence that anyone overdosed, and again, we have no smell of marijuana or any other drugs, so clearly there is no evidence to suggest that somebody might have overdosed in the room. The government then makes the second argument, that the officers needed to go into the room for efficiency. Number one, officers are busy, and this has now been their third time to the location. And in order to be efficient, because they're busy, they don't want to be spending the resources coming to the same location over and over and over and over again. Instead, they wanted to resolve the issue when they were there. Again, the court says that there is no exception to the Fourth Amendment requirement to get a warrant before you conduct a search based on efficiency. That is not one of those exceptions. And so the court says the community caretaking exception in this particular circumstance does not apply, and thus officers did in fact violate the Fourth Amendment when they initially entered the room. But remember, Mr. Hughes also argues that the subsequent searches with the warrant should also be suppressed. Here's what the court says. As noted above, defendant seeks to exclude not only evidence seized during the warrantless search, but also evidence that was seized pursuant to the warrant, that the officers obtained using information obtained from the legal warrantless search. Under the fruit of the poisonous tree doctrine, defendants may seek to suppress not only evidence obtained as a result of an illegal search, but also evidence later discovered as a result of that search. The doctrine clearly applies in the instant case. Evidence obtained by the police pursuant to the warrant will also be excluded. I hope you've learned a little bit more about the community caretaking exception. The companion exception called exigent circumstances that I've briefly mentioned in this video clearly did not apply on these facts. There was no exigency, and so the court did not actually discuss it and instead focused only on the community caretaking exception. And finally, I hope you were reminded about the fruits of the poisonous tree doctrine, which says that not only the direct evidence, such as the initial search, should be excluded, but also everything that follows. So that warrant is getting thrown out, and all the evidence that was found using that warrant will also be thrown out and cannot be used against Mr. Hewitt in trial. If you like this video, please give it a thumbs up, subscribe to my channel, hit that bell notification button so next time I post you'll be first to know. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, please consider going to losthash.com and purchasing one of these t-shirts that say "Do not arrest this person" or my Padre one. Thanks for watching.